Hi, everyone. We are letting folks in the waiting room, and let me just grab that link. Okay. If you haven't seen the Google Doc that has some of our situations on it, I've dropped it into the chat. Okay. Well, hi, everybody. I know a few folks will still be coming in from the waiting room, but I am Lee Williams. And I know many of you, and it's great to see you. We've had a really great response to this topic, and it's not surprising at all because I know that it is the source of some frustration, anxiety, concern, and a lot of discussion with your colleagues on your campuses. So College Autism Network is really happy to provide an opportunity for this discussion with three colleagues of mine who I think have a lot to bring to this. I also want to just make a note, of course, Brittany Jackson is behind the scenes and is part of CAN, so thank you, Brittany, for doing a lot of the back of the house tech. We are all spotlighted, but you are, as you come in, you are in the gallery, so your names and faces are on the screen. And when we shift to more of a Q&A, I can unspotlight people and we can then see more of the folks who are here. So I'm going to ask you to keep muted for the first part of this webinar, and as questions come up, please do drop them in the chat, and Brittany and I will be kind of watching that chat and either taking the question in the moment or when we have a little bit more time after our panelists have some opening remarks.
Sure, thank you.
So with that, I'm going to, well, let me give a quick outline of what we're going to do today. I'm going to ask each of our panelists to introduce themselves, to share something of what they think is kind of a key idea or topic that they hope we'll discuss. And then we're going to turn to these situations, as we've called them. We didn't want to be as formal as case studies, but situations that have arisen, and some of those have come from the AHEAD listserv, some of them have come from some of our attendees. And we're going to do that, and then we'll open it up to questions and comments for the last 20 minutes or so. One request that I have of all of you is there are about 50 people here, 60 people who've already logged in, and you all represent a variety of institutions and students. And so when you are asking questions, we hope that you'll be able to keep your questions kind of generalizable. In other words, the big picture, less specific detail. Sometimes it's really easy if you have competent people in front of you, you want to ask them about a very specific incident on your campus. That's not really as helpful to the other people who are here. And that will allow us to get to as many questions as possible. If that all sounds good, I'm going to turn this over to start with to my former colleague at the University of Connecticut, Kathy Cox.
Hi, everyone. I'm Kathy. I work for D. Stafford & Associates, and we're a higher education company that works with schools on a variety of issues. My background is really student conduct and threat assessment, and has been my jam for a long time. Lee asked me to spend about 5 minutes explaining the difference between Title IX and conduct, and I think I'm going to be able to do it, Lee. So, so here's a very quick scenario in terms of understanding why some things go under Title IX and some things go under student conduct. So in 2020, the Department of Education amended the Title IX regulations. One of the things I think it's important for people to understand is that they only amended the sex-based harassment piece. There's other regulations that have been in effect since 1975 that are still in play. Now, a lot has happened in the last 5 years, which we won't talk about, but the bottom line is that we're all under these amended regulations that came into play in 2020. And what those regulations did was that they implemented a very prescribed adversarial model for sex-based discrimination. And so when we say sex-based discrimination, that's sort of the big umbrella term, which includes sex-based harassment. And that's what really the amended regulations focused on. And so when I say sex-based harassment, I mean quid pro quo. I'll give you an A if you have sex with me. Hostile environment, sex-based harassment, that is unwelcome sex-based conduct that a reasonable person would find to be so severe, pervasive, and objectively offensive that it denies a person equal access to an education program or activity. Now, the third prong in this, which is what we see mostly with students and students versus students per se, are what we call the VAWA offenses. And those are the Violence Against Women Amendment offenses that amended the Clery Act. And that's sexual assault, stalking, dating violence, and domestic violence. Now, here's where it gets particularly complicated. Because what you have to understand about all of these, but particularly again with these VAWA offenses, is that for a case to fall under Title IX, it has to meet certain jurisdictional criteria. So it must have occurred in an education program or activity, which means that we exercise substantial control over the respondent and the context in which it occurred. It must have occurred in the United States. So a study abroad program doesn't fall under Title IX jurisdiction. And that a complainant must be participating in or attempting to participate in an education program or activity. Okay. Now understand one thing about this, that at some point we may see the courts make a decision if people file lawsuits as to whether or not that jurisdictional criteria is too thin. For example, the study abroad piece. But right now, that's where we're living. So if it doesn't fall under Title IX jurisdiction, it falls under either your student code or your HR policy. And so I'm going to give you an example of what sort of the jurisdictional challenges live. Let's say that you have two roommates and they go out on a Friday night. One roommate goes to a party at an off-campus house. The other roommate goes to a party in a residence hall on campus. Both are sexually assaulted by students. The off-campus incident doesn't fall under Title IX's jurisdiction. The residence hall incident does fall under Title IX's jurisdiction. And you all have different policies that probably manage that differently. You may have one policy that is strictly Title IX. You may have a sexual misconduct policy that includes both Title IX related cases and non-Title IX related cases that may follow the same process, or they may divert at some point. Or you may have a Title IX policy and then everything else goes under your student code. So that's kind of where the complicated piece is, that you could have a case that has almost all of the same characteristics, but it doesn't fall under Title IX. And there are two, in the Title IX world, as I said at the beginning, is a very prescribed adversarial process, which is not the way that really good student conduct processes work. Student conduct processes work as educational administrative processes. So that's kind of where we're at with that.
Thank you, Kathy. That was helpful context, I think, for some of the discussion that we're going to have. John?
Yes. Hello, everyone. My name is John Caldora. I'm currently the Assistant Director for Student Accessibility at Sacred Heart University in Connecticut. The point that I'm going to briefly talk about in a couple sentences is just being aware that our parents and students probably don't realize the shift between disability accommodations in K through 12 and disability accommodations in higher ed as they relate to behavior. That's because in K through 12, behavior is something that through an IEP can be accommodated for in some limited circumstances. And as we've seen more and more school districts go for the least restrictive environment option, This becomes more and more, which I'll tell you, K through 12 teachers have differing opinions about. The thing is, they do not realize that once they get to higher education, behavior and codes of conduct are effectively an essential learning function. And therefore, that is not something where we can provide a reasonable accommodation to, say, exempt someone from a code of conduct. That's not something that we are going to do. Best way I describe it is, in higher ed, disability explains behavior. Disability can inform the sanctioning and restorative actions, but it's not going to excuse behavior.
Great summation, John. Thank you. And I saw in the gallery, the bit that I have, a lot of heads nodding when you talked about some of those challenges especially with families. Next up is Allie. You want to introduce yourself?
Sure. Hi, everyone. I'm Allie McNamara, Director of our Aspire program at St. Joseph's University in Philadelphia. And something that we'll be highlighting today throughout the scenarios, but wanted to make a note of, is really trying to determine the distinct difference between annoyance and disruptive. We're talking about a few really exciting scenarios today, and really thinking about the impact that behavior may have on the learning environment, and is it sustainable but annoying, or is it disruptive enough to really impede on the learning environment? So we'll discuss that throughout the scenarios as we go on.
All right, thanks, Allie. And I'll drop the link in again to the document that's got some of these situations on it. So why don't we get started? I'm just going to read them. You can read along with me, and then ask Kathy, John, and Allie to kind of share some of their initial thoughts and some of the ways in which they might navigate these situations. So the first one, disruption across campus. A neurodivergent student with several psychiatric diagnoses has been reported by both an instructor and an advisor for some challenging behaviors. The student reports feeling overwhelmed from anxiety over being late while needing to wait for elevators, feeling like there are too many students in a classroom, and not having a private place to go when feeling this way. It's been reported that the student appears agitated, crying, lying on the floor, hitting themselves. Beyond encouraging the student to make use of accommodations such as class breaks, fidgets, permission to wear headphones, and using an empty office as a place to de-escalate, can anything be done? And I lifted this literally from the AHEAD listserv. I know that it is on someone's mind. So Kathy, John, Allie, who'd like to kind of start with your thinking about this situation?
I can start. I would say, on the face of that this is a student code issue. And part of thinking about disruption, and Allie mentioned there's a difference between disruption and annoyance, is that is there a behavior that is preventing another person from engaging in your program or activity? Now, if the student goes back to their residence hall room and they lie on the floor and they cry on the floor and they, hit the wall, whatever, that is ultimately their choice. But we can't be in a position where the academic environment is being disruptive. And again, and I think that disruption piece has to be done objectively. And so it can't just be a faculty member saying, I'm annoyed, or somebody else saying disruptive. But this is a behavior. And as John said, the person's disability may help to explain the behavior, but it's still a code issue, because student codes there are two parts to a student code decision. One is, was the code violated? And then the second part is that response, that sanctioning. That's where somebody's situation comes into play. But the reality is that you can't lay on the floor, you can't hit yourself, you can't cry, you can't be agitated, you can't be disruptive in the academic and community setting.
Thanks, Kathy. Go ahead, Allie.
I just want to say that I think that the accommodations that have been offered here are appropriate, right? And I think some of the issue here is that it sounds like the student is not utilizing those accommodations and support. So, I think that that's something to consider here, is that there's already been some work done. There's been some effort to try to help the student to either limit some of these triggers that have, caused them to be upset. Um, so I think as the question of like, can anything be done? I think it sounds like there's already been some work done proactively or positively. But when a student is not willing to meet someone halfway, right? They're not willing to meet us and say, I have these challenges and you're offering me some solutions and we're going to try those solutions. It's really hard to move forward with that student without the cooperation.
Yeah.
I think something I'll add in is this is a scenario that requires a longer term view, because you're getting, and this is something that an interdisciplinary care or behavioral intervention team should be managing on an ongoing basis. And that's because this does not seem to be related to a sensory issue or perhaps a one-time elevation in emotion that's leading towards, the emotional volcano erupting once. This seems to be an ongoing behavioral pattern. So it's important that we want to look at what are the underlying stressors that the student is experiencing, and also how can we work with that student to make sure that they are regulating that stress. Are they too worried about masking that the masking is not having any effect? Or is it perhaps that there are other factors from the other psychological disabilities mentioned? So really, this is a situation you need to think about from a longer term perspective.
John, that brings up an interesting point that we heard about in the first webinar that we did, where we had Allie, John, and Madeline Wessel, who's a university counsel. And one of the things that Madeline really emphasized was the importance of involving university counsel really as a situation begins to unfold, and not waiting until it's such a crisis that it requires immediate response. And it sounds like you're saying something similar, like let's start addressing some of these concerns early on and see if we can't get ahead of this situation.
Right. Yeah, and this is similar to a situation I've dealt with in the past while I was working as a case manager for a care team, in that we had to do the student, in addition to having these disruptions, also had some significant communication issues. And so we, in order to understand the student, actually went all the way back and looked at their admissions essay in order to get an understanding of what brought them here. And really from that point and making some basic sensory adjustments, we were able to have a much more productive experience with that student, and also connecting the student to resources. We were privileged in that we had a very large hospital right next to us that we owned, but making sure that you are connecting that student to resources in the community and following up with that student and making sure that they're using those resources, and if not, why not?
Great. Thanks. And the topic that I want to kind of put a pin in, because I think it will come up here, is the notion of otherwise qualified. And at what point does that discussion become kind of primary in the response to students like this? So we'll come back to that. But and I encourage anybody in the audience who has any questions as you're hearing John, Kathy, and Allie talk to just drop those in the chat. The second situation, which I think also might have come from the AHEAD listserv, involves a student with Tourette's syndrome. 2 faculty members have reached out to the Disability Services Office staff about a student with loud and frequent, about every few seconds, vocal tics, saying they are disruptive and make it difficult to teach. It is also difficult for others in the class to focus. The instructors understand these tics are involuntary, but are unsure how they can continue to teach the class effectively. The DSO staff have spoken to the student about strategies to help them manage their tics, which have reduced, but not eliminated them. And so we have sort of a similar situation to the case above it, where there is a disruption happening in an academic environment, but a different diagnosis and a different set of responses. Allie, Kathy, John, who'd like to weigh in on the situation?
I think this is a tough one, and disclaimer to the audience: this small group has already talked about this a little bit, and I think the more we discussed this the other day, the more kind of thoughts I had about it. Um, it's tricky for me. I mean, Tourette syndrome is not an area of expertise for me, so I think I'd want to know a little bit more, and maybe the people involved here would benefit from some deeper diving into that diagnosis. But the involuntary part is really what sticks out to me, is that I don't know what the alternative here is. I don't know. And Kathy, I'd love to hear from you a little bit, like, you know, what accommodations might be able to be made that doesn't change the learning environment or bar the student with Tourette's from participating in an educational experience, right? We had talked about some ideas of, perhaps the student being able to participate virtually where, sound could be turned off, but does that change the educational experience for the student? And is that allowed, right?
Yeah, this is a really complicated case. And when we had talked about it earlier, and I was thinking back to, because I had remembered that I had some kind of a similar situation back when I was in student conduct. And so there's sort of a couple of things about the student conduct field that I think is important, is that we are educators, right? We're in the education business, and we often look at things from the standpoint of, again, is this a policy violation? Was there formal sanctions, etc.? But there is another component of student conduct offices, hopefully, where that's the most formal part of our process, but we do a lot of conflict resolution, right? And we also do a lot of behavior management and helping out. And when I was thinking about this week, I remembered having a similar situation, and I was trying to figure out how we resolved it. And part of it was that I remember I had one of my staff members went to the class about 3 or 4 times, and he looked young. The faculty member knew who he was, but nobody else knew who he was. And he just sat in the class because of part of that issue of, is it annoying or is it truly disruptive? Is it more difficult than somebody that has a cold and that is coughing and sneezing in the class, right? So being able to, I think one piece of it, and I think that this is where, again, student conduct offices can be helpful because they are sort of that objective person, right? And typically, I don't have expertise in Tourette's, but I was able to send in a staff member who could talk about whether or not it was disruptive in the class or not. So I think that that's one piece is I think we always kind of have to check in terms of, what does it mean to be disruptive, right? Is it really being difficult? And then I think we have to look at, every situation differently. And again, the accommodation world is that's not, where I make the decisions in the accommodations. But I think from the conduct standpoint, some of the questions that I would ask in working with my disability services person is there a reasonable accommodation, right? If they're in a lecture hall, and this kind of goes to what you're talking about, Allie, if you're in a lecture hall and we're able to record that student, we live in a Zoom world now, are they still able to engage? Is that diminishing their academic program to the extent that it is really, they can't be successful, right? Now, if it's a lab class, that's going to be a different story, right? And then that begs the question, and I think this is where general counsel comes in, gets involved, is that person otherwise qualified to be in that class? If this is truly a disruption and it's involuntary, right? So the vocal tics are, they can have done some things to manage those, but they can't eliminate them. What does that mean in terms of them being otherwise qualified? And I think that's a much bigger legal question, right? But I do think that part of it is, what are some things that we can try to do before we even get to that point? And part of that is getting ourselves in that classroom to see what's going on, to have an understanding, to try to get manage that referral source, manage that instructor or the multiple instructors in terms of, what is it making, what's making it difficult for them to teach, and are there things that we can do to try to minimize that?
Thanks, Kathy.
Yeah, I think the point I'd quickly add here is the fact that the student is using the strategies and that they are to some extent working. This is a student who is trying to make an effort, and I think that is an important point to highlight here, and that is why, in my view, this kind of moves more into the annoyance column rather than the disruption column, because this is not an intentional behavior. And if you say replace Tourette's with another disability, like for instance, a student has an ASL interpreter, could that be seen as disruptive? No, probably not. But could that affect a professor's ability to, teach? That is something, that is an argument a professor might make. Now, that argument is going to go absolutely nowhere with any disability services office, but it really goes back to that line that Allie was discussing at the beginning.
Right, and one of the overarching questions for us really is who gets to define disruptive, right? Like, is that a legal term or is it really a more subjective term? I'm going to actually skip down to autistic student making threats, because I think that some of this ties together a bit. A student known to be autistic was arrested for making online threats to, quote, shoot up the campus with a Glock. The student explained that a characteristic of their autism is anxiety with depressive episodes, which manifests as outbursts, including threatening words and behavior, but says they would never act on these, and there's no known history of actual violence. The student has a behavior contract because of previous incidents, but believes the contract violates their rights under ADA. So is that a thread we can pull on a bit? I'd like to start with that.
My first thought is, the threat was made, and especially in today's political climate and world, I don't see how the student can't be held responsible. Like, the student must be held responsible for the threat. It's a campus safety issue. It's a safety to others issue. Once you've kind of, said that those words, it's kind of like putting salt back into the salt shaker. You can't really unsay it. So I think this would be really tough to say that the threat, was specifically, or whatever, would be excused by the disability.
Yeah, and I would say, and I'm going to go back just for a second to something you said, Lee, in terms of determining what's disruptive. There are people on campus who have been, in essence, authorized to decide that, right? Student conduct, Title IX, those are the folks who determine what disruptive behavior is from various policies. And I think similar to that, I think connecting to this is, as Allie said, you can't do this. That it's a violation of the code. And I would say, and again, this is where we have to look at it from the standpoint of that is not an institution's expectations that you can do that. In that there are often sort of two types of behavior, to really kind of narrow it down. There's almost really sort of two types of behaviors. What I would call a victimless act, and then one where somebody's been harmed. And so if somebody goes and steals a book from the bookstore, which I recognize that the bookstore is a victim to an extent, but I think you know what I mean, right? There is but that there's nobody really significantly harmed by that, right? We can do some restorative stuff and life is good. But there are these violations that happen, these behaviors that are impacting that are impacting others. And when we talk about violence, there was a point when people used to say, the best indicator of future violence is past violence. And the research that's coming out of groups like the Violence Project is really saying not so fast, because we're seeing more and more where a person has not had, this is sort of their first time, and they really kind of went big and they went big with it. So I think that there's two issues here. One is that it is a conduct issue, and it is also going to be your threat assessment team's issue. That they have to, because your threat assessment team needs to really look and explore if the person poses a threat. Your conduct has to manage the fact that you can't make threats, and then again, that second part, it can't excuse the behavior. It may help to explain the behavior, but we also can't we have an obligation to both individuals and communities. And there's a lot of times when we can do both. And then there are times when the community is going to win out. And making threats about shooting and campuses and stuff is problematic. But that's where it needs to live in both places. The behavior needs to be addressed through the university's expectations, but your threat assessment team should also be examining the situation.
Great. I'm sorry, go ahead, John.
I just want to add in for this case is particularly that last point about the behavior contract being tied to the student code of conduct. That is like crossing the streams in Ghostbusters. That is bad. That's something you don't want to do. Really, if you are using such behavioral contracts, that is something that you should be tying to some other process that's more appropriate. Like if you have an involuntary medical leave process that, say, offers a student a refund if they are removed through that process, that would be more appropriate and also probably more in line with what you're doing with other students. I'd say that, the school, the actual case that this happened on, I use as an example a lot of basically this is the exact wrong way to handle a case, but Lee has changed it here in such a way that it is not the wrong example. But I would have focused on that threat and not on the behavioral contract as I was adjudicating and providing a rationale, because that very much opens the window for a whole lot of things like lawsuits and DOJ investigations and things like that.
Yeah. I tend to recommend people, and I understand that this can be a excellent tool in terms of having people understand boundaries and whatnot. Calling it a behavior contract, I think, can be problematic because you already have one, and that's your student code. So if you are, helping them and coming up and have worked with, and worked with students and student conduct people have done similar things in terms of, here are some things that we want to help you with in terms of boundaries and limits and what's appropriate. But when we start talking about behavioral contracts, you already have one. And it can't supersede the code. It can't contradict your code. And as John says, the consequence of not following it can't then also be kicked to your code.
Great point. One of our attendees sent a note, I think maybe just came to me, but asking about, can we unpack intentional versus unintentional a bit more? So tics are unintentional, but all of you deal with students who might say that their meltdowns or panic attacks are unintentional, and how do you navigate those differences? And this really gets us to that question of otherwise qualified, but going upstream, intentional versus unintentional, does it matter?
It matters to an extent, but something that I hear a lot from and I work very closely with our community centers in Title IX, and but that impact to community is what I hear a lot, and whether it's intentional or not, I like Kathy's thought of kind of the victimless crime, versus impact on others. And yeah, I think that, it's hard because sometimes, every student is so different. But I do think when it comes to something this severe as, threatening a school shooting, while the student is saying he did not have the intention of doing it, he did have the intention of saying it, right?
Mhm.
There was nothing involuntary about him saying it on a very basic level. Whereas opposed to Tourette's, there is a very, very involuntary process. If a student with Tourette's screamed out, I'm going to shoot up the school, I guess I'd have a little bit of a different opinion about that. And again, I'm not an expert in Tourette's, but from my limited knowledge, there really might be no intention from that person. But for this student in particular, there was intention in saying it, even if there wasn't intention in following through.
Let's skip to this last one because, and we're going to come back to some of these issues, but student conduct hearing is something that I think autism support professionals often do get pulled into or asked to advise on, or your expertise is sought out. And so in this case, a student with documented disabilities is facing a student conduct hearing for several related issues: disruptive behavior, accusations of harassment and stalking, failure to exit a residence hall during a fire alarm. The student is making accommodation requests for the hearing, including having a therapist in the room as an advisor, bringing in autism experts involving parents, and potentially an attorney in the hearing. What kinds of accommodations are permissible and helpful to being sure a student is appropriately supported during a hearing like this? So the situation has reached that level. And if a student is found responsible, what are some of those potential sanctions, and should they be any different than if a student without a disability was found responsible?
Well, in terms of accommodations, and I think this is again, and I would say that I really recommend folks to go back to your institutions and to read your student conduct codes, because they should have an accommodation statement in the code that directs them to your accommodations person, so which is probably most of you on the call, so that because a student conduct office should not be making a determination on accommodations. And so that should really be a collaborative thing, so that disability services understands what a conduct hearing or conduct meeting looks like. So typically, students can bring a support person or an advisor. And so that's a very common piece. And usually that person is a little bit of a potted plant in terms of they can't actively participate in a hearing, but they can provide advice, they can help their student, but the student still needs to be able to speak about the issue or answer questions. There are some schools that will consider an accommodation being an additional support person whose sole purpose would be to provide any kind of support around their disability. So if somebody's having a hard time with, say, emotional regulation, that they may have an advisor to kind of walk them through and talk them through the conduct piece, but then there might be somebody there that's going to provide sort of that support. That's not uncommon. I think there are other pieces where, and again, I always go back. I worked with a director of disability services, and she always used to say that if we think about accommodations, oftentimes they're just really good for everybody, right? That if and so I think about that, and I think about that in terms of conduct pieces, is that the more that we have opportunities for students to provide information. So if I have a student that's not particularly good with speaking, that I give all of my students opportunities to also provide a written statement. So I just have to ask questions, right? So I think thinking about those kinds of things is sort of a little bit bigger picture. Now, in terms of involving parents and potentially an attorney in the hearing, a little bit about this is a little bit state, because there's a couple of states that let attorneys represent them. So I'm going to not talk about those states. Typically, we don't allow that. And I will say I had a situation once where I had a student who had made some threats, significant threats, very publicly. And he had said that because of his disability, he was not able to participate in a hearing and would need an attorney. And the disability office said, then you are not otherwise qualified. Because part of being a student is being able to participate in the process. And so then he did withdraw, and I will say it was probably 6 years later, showed up again and said, I've gone through treatment, blah blah, all of this stuff, and even though I'm not going to come back to your school, I would like this matter to be resolved. So which was I think sort of a nice closure for everybody. So that I don't think is a reasonable accommodation. Again, some states you do allow representation. And then the second part is if a student's responsible, what are the potential sanctions? And should they be any different if a student without a disability was found responsible? The sanctions. Here's the way that I look at sanctions. If all things are equal, you probably have some kind of a standard sanction, and then you have mitigating and aggravating factors, things that increase the sanction, things that may decrease the sanction. But a part of that, so if you're looking at these, these behaviors are very problematic, and the student would likely be facing a suspension or a dismissal. Really what the conduct office would look at is, are there any mitigating and aggravating factors? And again, a disability can't excuse a behavior. It may help to explain a behavior, but again, they're going to have to look at the whole picture. So you can't be in a place to say, this is going to be different because that person has a disability. It can be a factor. If a student puts their fist through the window, and one student did it because they were drunk, and the other student did it because they had just found out that a family member had died, they both violated the code, ultimately. Will those sanctions look a little bit different? Probably, right? And we do try to live in the education world, but part of the question always is how much harm has been done to the community, and can that harm truly be repaired with the person there? And that's a complicated question. So, and I see a question when the student was told regarding otherwise qualified, when they said they couldn't go through a hearing. So the disability office said that there was no reasonable accommodation to allow someone else to speak for them in the hearing. And therefore, the disability office says, if you can't participate in this hearing, then this means that you're not otherwise qualified, because you have to be qualified and able to meet the standards, those sort of technical standards. And one of those at the institution was the fact that you don't get to speak for somebody else.
So yeah, I'm going to point to that question, and I had a case like that happen once, where due to a mental health disability, a student was not sufficiently connected with reality to understand a student conduct process. In that case, the student was instead involuntarily medically removed from the campus because you are not otherwise qualified, as Kathy is saying. But we are not going to remove you through a process that you cannot competently participate in. We'll instead use the appropriate lever or mechanism to do that. I also wanted to speak to the question about that. Are we in the questions period now, Lee?
Yeah. Yes.
Okay. About guardianship orders. So I checked with a couple years ago with basically 3 of the top legal minds at a head. Jamie Axelrod, Paul Grossman, and Mary Lou. And having a guardianship order in of itself does not mean a student is not otherwise qualified. The way that I've dealt with that in my practice is that involves more communication with parents than expected, and also involves telling faculty members that, unlike with 99.99% of your students, in this one case, if a parent speaks to you, you actually have to talk to them. Because there often is an educational decision-making component. Now, thankfully, knock on wood, I've never had to deal with a guardianship order in a student conduct case, but if I did, that would probably go to the question of otherwise qualified at that point. But having a guardianship order in of itself does not mean that a student is not otherwise qualified.
Thanks, John, and Kathy for that. And I'm going to leave you spotlighted for another few moments, because I think that we've sort of gotten close to a third rail in this area, and John mentioned it. The voluntary versus involuntary removal. So, who gets to decide that a student is not otherwise qualified to be enrolled in the campus? And I totally understand. We all understand the pressure that many of you are under to retain students. And so how then do you navigate the student being potentially not otherwise qualified? And also, involuntary medical withdrawals are not okay on a lot of campuses, and there's been case law that has made campuses very wary of doing that sort of thing. So let me just ask that. Where does the decision to just determine otherwise qualified rest, and how can attendees here today who are working on behalf of students but also representing the institution be part of that process, that discussion? John?
I'll just say it does not and should not rest with a single person.
Yep.
This is a decision that needs to involve multiple parties. It needs to involve your disability office, probably your legal counsel, probably if you have a case management office, it needs to involve them. And if you have an academic ombud or someone who can act as a neutral person to speak to academic qualifications, them as well. This is not a one person making this decision. This is you need to have a serious thought out process. And like Lee said, campuses have turned away from involuntary medical withdrawals. And I agree that, there are some campuses out there that we're overutilizing them for things that they should not be utilized for. Like, for example, you go to a hospital for a suicide attempt, we're going to involuntarily withdraw you until you get your act together. That's not an appropriate thing to do. There are other more effective methods of suicide attempt postvention that you can do while a student is still enrolled. On the other hand, a student who is disrupting a community and beyond the scope of services that's offered by your university, again, not a decision an individual is going to make, but something where you're going to want to have that discussion. And you're also going to want to have very clearly laid out policies and procedures for such a discussion.
So let me bring some of us into the, and this is an opportunity to ask some questions. If you want to raise your hand, or sorry, I'm trying to figure out how to spotlight John. Oh, there it is. Okay. So if you'd like to raise your hand or unmute or just drop it in the chat, we'd love to hear some of the questions that have been provoked or that you've come to today's session with.
Hi, I have a question. This is Kelly Searsmith,
Hi, Kelly.
CAN member. I do not work in your position as a disability support person, but I am a researcher and an autistic advocate in this area. And I wanted to ask, very often autistics will say, and some of the research shows that their behaviors and their utterances are often misinterpreted by others in stalking cases and other things that have come up, and the student expresses surprise that they were deemed inappropriate or whatever. So, how do we take into account this interpretive factor when a student says that their behaviors, their utterances have been misunderstood, not where it's clearly a threat or something like that, but say in interactions with a professor, um, and the student has been blunt or hasn't acknowledged hierarchy or something of that kind, and the professor says that they're out of bounds and can't work with the student. How do we deal with this interpretive dimension of autistic behavior and utterances? Thank you.
Thank you, Kelly. Kathy, John, or Allie?
Well, I think that that's a great question. And, I think part of, all of our roles, and I'll speak obviously from a student conduct lens, is that my role is to um, support students. It's to support all the community, folks as well. And that, part of why student conduct offices exist is to make sure that people have their rights. And there's a lot of referral management that comes into play with that. And so I think part of it is being able to work with not just the student, but whoever has this concern, to talk exactly about what you talked about, Kelly. That, we know that, when I work with schools, I hear all the time that students with autism are disproportionately referred to conduct offices. They're disproportionately referred to care teams. And my always question is, who's the one that's uncomfortable, right? Is the student really the issue, or is it that you're uncomfortable because the student is different, right, than what you think it should be? Not even necessarily that they are different, but that you have this vision of what somebody should be. And I think that that's where that conflict resolution, we never want to be in a place where all we're doing is, you violated this policy, here's a sanction. You violated this policy, here's a sanction. That's not the world we want to be in. We want to be in, how can we make this be a successful place for everybody? And I remember I worked with the same student for his whole 4 years, which sometimes included some suspensions. But we would work with students. People would come and say, "Well, he said this to me," and I said, "Well, how is that different than if someone else said that to you?" "Well, they make me uncomfortable." What is it? What makes you uncomfortable? So part of it is really focusing on behaviors and what's actually said. But part of all of our roles is to really look at what's the underlying issue, right? And oftentimes, we'll have people who will say, "Well, I'm afraid of the student." Well, we know that actually people with disabilities are more likely to be a victim of violence than to be someone who commits violence, right? And so I think part of it is part of all of our role, and don't think that that should just be on disability services. All of our role is, how do we help and support our students? And part of that is having some difficult conversations, sometimes with faculty and staff, in terms of their own biases or their own responses to people who might just be different than that, and they might not be used to it.
Very great. Great thinking about that. And I hope that's helpful, Kelly, as you listen to that. A couple of other questions have come up that I think are pretty interesting. So where does the determination that someone is not otherwise qualified rest institutionally? I can say that is going to be kind of institution specific. That is often in the Dean of Students office or the Vice President for Student Affairs, but it might also rest in the President's office. And I think we have to go back to what's been advised, which is this is a team decision. And documentation is going to be essential. Looking at Bill's question about, will this pass muster with OCR? Is it defensible in litigation? If your institution finds itself in either of those situations, being investigated by OCR for an unreasonable dismissal or litigated against because of that, the court is going to want to see the documentation that has come along with that situation. And that's where we go back to what Madeline said in the first webinar. Early involvement by university council whenever possible to advise on that process, because ultimately it's going to be a university council who defends the decision in court or with OCR if it goes that far. So documenting it and then recognizing that there is a team involved, a multidisciplinary team involved in this decision. So who actually signs the paperwork is going to be specific to your institution, but the process to get to that point has to be consistent. Lots of documentation, lots of involvement from people, and no surprises. It should never be a surprise to a student that this decision has been made.
It's something I'll clarify here is that I see two types of otherwise qualified issues. The first is an academic issue. A student was admitted but does not have the capability to perform the coursework. This sometimes comes up if a student is in a program where they worked to their individual ability and not grade standards, and their diploma was not properly coded to say as such, so it looks like they have a 3.8 GPA when they do not. And this is happening more and more as our institutions have gone and remain test optional. In those cases, some of the solutions I've seen are if the student has an intellectual disability and you have an intellectual disability program, perhaps pointing the student in the direction of that. Otherwise, honestly, the answer is support the student the best you can and provide them all the appropriate levels of support and accommodations that you would provide any other student, because it's not exactly like we can say you can't be here because of this reason. Because kind of once they're in, you've kind of already opened the barn door. The other kind is where we're talking about a behavioral or health and safety issue, which that goes beyond just disability, but into also trauma, medical issues, and that's why having that team and having that process and also being compassionate about it. If you are removing someone involuntarily, you should be giving them their money back, and you should be trying to alleviate any sort of harm or potential harm and doing it in as compassionate a way as possible.
Generally speaking, I am not a fan of involuntary withdrawals. I would, again, Bill, I agree with you wholeheartedly. I will try to do everything possible to try to, have this come to a good conclusion. Because involuntary withdrawals, I think you have to be very careful with them, so that you're not bypassing a legitimate process. So I think that there is a piece of it. But I do think that this issue around otherwise qualified and involuntary withdrawals really comes to your question. And I don't think that universally institutions do a good job of saying, what does it mean to really be a student here? You're not going to have a million friends, and it's not going to be a beautiful sunny day every day. But I think we have challenges because schools can say, hey, you can be whoever you want. You want to be a nursing major? That's great. Well, maybe you can't be a nursing major. I'd love to be a professional golfer, but I've never seen a tree or a bunker that I didn't like. So, that's not going to happen, right? And so I don't think that we do a great job. And I think that sometimes with our students and their families, because of the K through 12 that they are, the support and what they're entitled to there versus what happens when they come to college. I think that you all do a great job of explaining that, but oftentimes it's a little bit too late, right? And I think really trying to work with our admissions and our communications, because that's where it's falling, is come here and it's going to be fabulous, when we're not really being transparent about what that means. And then that puts us in a position of saying, um, you know, of saying later that you're not otherwise qualified, and that becomes very challenging.
And that brings us to the top of the hour, which leads me to believe that we need a part 3 webinar, because I think that this issue of otherwise qualified, you know, to answer Kay's question, there really is a process and a way to explain that, and I think Kathy's right. We don't do a very good job. We don't do a good job figuring out where our leverage points are to remove students from situations where they're not succeeding and they are disrupting others. So what I'd like to do is invite Kathy, John, and Ali back again. Send you all an invitation to a subsequent webinar where we can dig in a bit more on those issues. How do we respond to students in sort of dire situations, and how do we protect the experience of the other students, faculty, and everybody else on our campus? You will be getting an email with a link to this recording and an evaluation to fill out. It's very brief, but it just helps us know if we've hit the target. And yeah, I would love to have a third part to this to dig in a bit more. Obviously, it's something that's really top of mind for many of you. So with that, I'm gonna wrap us up because I know people have lives to get back to. And thank you all. I want to say thank you to Kathy, to John, to Ali for being part of this great discussion, and thanks to Brittany for the tech. It's great to see you all, and so stay tuned for part 3. Bye-bye, everyone.